This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant, expert witness, author, and producer of these videos. Today, a little change on the covenant of good faith and fair dealing and the obligation of insurers to treat every insured with absolute good faith. This time we're going to talk about the duty of the insured, since the duty of good faith is equally imposed upon both parties. The purpose of the implied covenant of good faith and fair dealing is to protect the reasonable expectations of both parties to the contract. The duty to act in good faith is a mutual duty imposed on both the insured and the insurer. However, regardless of the clear statements of the law that the duty is mutual, in practice it requires the insured to deal only with a modicum of fairness toward the insurer, while the insurer must deal with its insured with the utmost good faith. In Washington state, a statute provides, quote, "The business of insurance is one affected by the public interest, requiring that all persons be actuated by good faith, abstain from deception, and practice honesty and equity in all insurance matters. Upon the insurer, the insured, their providers, and their representatives rest the duty of preserving inviolate the integrity of insurance." This is RCW 48.01.030. Even if an insured is found to have treated his or her insurer maliciously and with bad faith, the insurer can only recover actual contract damages and may not, for instance in California, recover punitive damages from its insured, although an insured may recover punitive damages from its insurer acting in exactly the same fashion. The courts will allow the insurer only to offset the bad faith damages it owes to an insured by a percentage the jury attributes to the bad faith of the insured. This statement of the law may seem unreasonable. If an insured is entitled to tort damages for the bad faith conduct of the insurer, the law should fairly and equitably allow the insurer to recover tort damages as a result of the bad faith conduct of the insured. At present, this is not the case. Examples of bad faith conduct by the insured can include: 1. Presentation of a fraudulent claim. 2. Misrepresentation of material facts, which, if known by the insurer, would have caused the insurer to refuse the insurance. And 3. Willful refusal to attend trial as a insured of a liability insurance policy. Since the insurer's obligation is absolute and independent, such bad faith conduct would not bar the insured's action. It could result in a comparative bad faith analysis by the trier of fact, and the reduction of any award the insured might have otherwise received. It would not, however, result in a reduction of punitive damages or other tort damages based upon an insurer's malicious, oppressive, or fraudulent behavior. An insurer argued to the Sixth Circuit that the court should recognize a cause of action of reverse bad faith in the insurance context and award the insurer damages associated with plaintiff's fraudulent claim. Defendants maintain there is a strong public policy against allowing insureds to profit from their own wrongdoing, while simultaneously subjecting insurers to inordinate increased costs for investigation, defense, and litigation. The court was unable to find any jurisdiction that has recognized a cause of action for reverse bad faith. The Sixth Circuit declined, as did others, to allow reverse bad faith in a case called State Auto Property versus Hargis, a 2015 decision of the Sixth Circuit. In Colorado, the court assumed without deciding that an insurer can assert comparative bad faith or fault of the insured as an affirmative defense in a bad faith action, but not as a tort by the insured against the insurer, regardless of the tortious and nasty content and conduct of the insured. In Kransko versus American Empire Surplus Lines, a 2000 decision of the California Supreme Court, it allowed that an insured's comparative bad faith, namely an insured's breach of the covenant of good faith and fair dealing, is not a defense in a bad faith action brought by an insured against the insurer. The Kransko court did not hold that evidence of an insured's misconduct is always inadmissible. To the contrary, the court noted that such evidence might be admissible to show, for example, that the insurer acted reasonably under the circumstances. In Oklahoma, the Supreme Court in First Bank of Turley versus Fidelity and Deposit in 1996 found that an insured's failure to give an insurer adequate notice with regard to a third-party suit against the insured when demanding that the insurer defend the suit does not constitute actionable conduct either ex contractu or ex delictu, that no action will lie against the insured for failure to give the insurer adequate notice of facts relative to coverage, even if the insurer could not secure them by discovery, that the insured's responsibility to provide its insurer adequate notice of facts relating to insurance coverage cannot be translated into actionable tort or contributory fault defenses for comparison with the fault of the insurer that wrongfully refuses, in bad faith, to defend, and although the insured who fails to give sufficient notice is not answerable ex delicto, the insured's inadequate notice avails to the insurer as a defense. Any duty of good faith does not provide an insurer with a claim against its insured in tort. A breach of this covenant is at best a breach of contract. A relationship including specialized circumstances of reliance and dependence is necessary to transmute such a contractual breach into a tort. Such circumstances, according to the California Supreme Court, do not exist in the context of an insured's responsibilities towards its insurer, or the reciprocal context of an insurer's legitimate expectations from its insured. An insured does not bear a risk of affirmative tort liability for failing to perform the panoply of indefinite but fiduciary-like obligations contained within the concept of insurance bad faith. The trial court therefore correctly sustained the insured's demur to the insurer's reverse bad faith claim. as found by Kransko versus American Empire. Case law suggests, in the context of insurance claims, that courts must be vigilant to ensure that plaintiffs not engage in reverse bad faith conduct. The duty of good faith between the insured and the insurer is a reciprocal one, but the plaintiff has a reciprocal duty to be straightforward and forthcoming in providing information necessary to the defendant's evaluation of the case. But that does not mean the insurer can obtain bad faith damages from its insured. This is a decision of the Massachusetts Court of Appeal in 1996 called Parker versus Diavolio. Most courts consider litigation to be an adversary proceeding, which once instituted suspends the duty of good faith. However, the California Supreme Court on the last day the Rose Bird-led Supreme Court was in power, ruled that the duty of good faith and fair dealing continued after litigation had commenced between the insured and the insurer in a case called White versus Western Title, decided December 31, 1985. The basic holding of White will eventually be rejected by the California Supreme Court if the court is given the opportunity. It is, however, currently and will continue to be the law until something changes. For that reason, insurers in California always seek a waiver of the holding of White versus Western Title before starting negotiations on any claim where there is a potential for a bad faith claim, because they have no recourse against an insured who acts in bad faith. Justice Kaus, in his dissent to the majority opinion in White versus Western Title, gave a warning to all insureds and attorneys for insureds in what may be, what in my opinion should be, a precursor of future decisions. Justice Kaus said, quote, "The problem is not so much the theory of the bad faith cases as its application. It seems to me that attorneys who handle policy claims against insurance companies are no longer interested in collecting on those claims, but spend their wits and energies trying to maneuver the insurers into committing acts which the insureds can later trot out as evidence of bad faith. Adjusters should heed Justice Kaus's warning and never give a lawyer the opportunity to trot out the adjuster's actions or statements as evidence of bad faith, nor should insurance company lawyers ever give a policyholder's lawyer the opportunity to trot out the insurance company's actions or its attorney's actions or statements as evidence of bad faith. This video was adapted from my book, Zelma on Insurance Claims, Part 106, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting and useful to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube or my Rumble channel and to my blog so that you can be advised of future videos and blog postings. Thank you for your attention.